So the next session is regarding the challenging and setting aside, and of course the enforcement of an arbitration award, which is the last start of arbitration proceeding. You know. So in the previous session, we saw that the drafting, the essential elements to be taken care while drafting an arbitration award. So once the arbitration award is drafted and it is being delivered to the parties, then obviously the mandate, that is the power of the tribunal, comes to an end. Even though if the parties, either of the parties, need some clarification or have some doubts in the arbitration award, uh, award copies delivered to the parties. In that scenario, of course, the UNCITRAL and every arbitration laws of the country, they have a provision for this correction and interpretation of arbitration award. So either of the parties, they could request the arbitrator uh, to, give some interpretation or clarify some doubts, or if there is any typographical error, so that error could be addressed and it could be rectified. So the parties, they could request the arbitrator to do that. So that request has to be made within a strict timeline. So this timeline varies from country to country. So it is generally, within 30 days, the parties have to make that request. So before making request to the tribunal, the party, whoever wants the clarifications, he has to send a notification to the opponent party saying that he needs so and so clarifications or corrections, and he wants to request to the arbitrator. He should notify that to the opponent party, so that opponent party, he should give consent for that request. Only then the party who is seeking clarification can make the request to the tribunal. So after getting the request from the party, the tribunal, if the request is proper and it is logical, then he will give his interpretation or corrections. If it is any typographical errors, he will do the necessary things. And if the party feels that any of the issues is not being addressed in the award, then he could also request for the additional award. Let me show an section 33 application, so that, sorry, this correction interpretation of award, interpretation of award request letter to the arbitral tribunal, so that you can understand more. So hope you can see this section 33
Yes,
application.
Madhu. Yes, Madhu. Yes.
Yes, sir. Yes, sir. So in India, we do seek for this interpretation and correction under Section 33 of Arbitration Conciliation Act. So hence it is called as Section 33 application, obviously. So here the party's name is mentioned, and the tribunal, the arbitral tribunal name is mentioned. That is, the cause title is being mentioned here, and the agreement and that is joint venture and memorandum of understanding. The dispute refers to these agreements, hence it is being mentioned here. And the authorized person of the claimant, because the claimant is the one who is looking for the clarification in this application. And the date of the award is being mentioned here. So here the claimant, he lists out the clarifications and the errors or the additional award. He makes as a list by referring to the arbitration award by the tribunal. So here did the tribunal therefore assume that the terms and conditions of the JV are not superseded by the terms and conditions of the MOU. So he needs a clarification on this superseding terms. So hence he's making this question. And of course, all the clarifications and errors, whatever the questions, it will be with question marks, obviously. Yes. So this is how the clarification and interpretation application looks like. So if you're making any application in the arbitration award for clarification or interpretation, make sure that you strictly follow the timeline as stipulated in the arbitration law of your country, and make the request as appropriate. And next is setting aside of an arbitration award. That is, if either of the party is not feeling good about the arbitration award pronounced by the tribunal, so in that situation, the parties has the privilege to challenge the arbitration award. So to challenge this arbitration award, you have to consider three things. First is the timeline, because the arbitration proceedings, it is very much time limited. Hence, the parties go to arbitration than to go to court. So to file the set aside application, you have to check the timeline of your country, that is Arbitration Act of your country. And next is the jurisdiction, that is the court where you will be filing the set aside application. That has to be checked. And the ground, I mean, and the
Sorry,
ground
Madhu,
based on which you, yes,
your
sir.
PPT is not visible.
I'm sorry. So now,
Now I think it is coming. No. Ah, yes, now it is visible.
okay. So as I said, setting aside of an arbitration award. So if either of the party is unwilling, is not satisfied with the arbitration award rendered by the tribunal, then they have the chance to challenge the arbitration award before the court. So that is called as setting aside of an arbitration award. So if you're filing a set aside application, you have to consider three things. First, the time limit within which you have to file this challenge petition. And next is you have to check the jurisdiction of the court where you will be filing this challenge petition. And then next is the grounds based on which you want to file this petition. So these three things has to be considered before you file the challenge petition. So any party to an agreement who wants to challenge, that is either respondent or claimant who wishes to challenge the arbitration award, needs to file an application for setting aside an award before the court. So that application has to be filed within the time frame as stipulated in the arbitration law of the country from the date of receipt of the arbitration award. So this timeline, it is very much mandatory. So if if the timeline has been passed, then you cannot have the chance, you could not avail the chance of filing the set aside application. So failure to file an application to set aside the arbitration award within this timeline typically results in the loss of the right to challenge the arbitration award. And courts are very much strict about the adherence to this timeline, emphasizing the principle of finality in the arbitration. So this timeline, it varies from country to country. So as per ancestral model law, the set-aside application has to be filed within 90 days from the date of receipt of the arbitration award. If it is UAE, it has to be filed within 30 days from the date of receipt of award. And if it is UK Arbitration Act of 1996, the challenge petition has to be filed within 28 days from the date of receipt of award. So if either of the party could not file within this time limit, obviously they could not. Their right has been waived, and they could not file the petition before the court. And if it is India, the parties are provided with 3 months timeline from the date of receipt of the award to file this petition before the court. And they are provided with additional grace period of 30 days. I mean, 30 days, that 30 days, if the court feels that sufficient and reasonable, logical reason is provided for that delay, then they will allow. So this timeline, you make sure that whether it is in month or days. If it is in month, you should strictly adhere to the months. If it is in days, obviously, it has to be days. Next is jurisdiction of court entertaining set aside application. So we have been mentioning about the place of arbitration and the seat of arbitration. So either it has to be in the arbitration agreement itself. If not, in the arbitration proceeding, the parties can mutually sit together and agree on the seat of arbitration. Although if not, the arbitrator has the power to decide on this seat and place of arbitration. So if it has been mentioned in the arbitration award, then the place, I mean, wherever it is mentioned, the parties could approach only that court. If it is mentioned as Singapore or UAE or India, yes, the parties have to approach the courts of that jurisdiction to file this challenge petition. So the seat of arbitration, it will be referred from the arbitration agreement between the parties, or if not, when parties choose a particular jurisdiction as the seat, they implicitly agree to submit to the jurisdiction of that country's court for any arbitration related judicial interventions. So, for example, if an arbitration is seated in Singapore, the courts of Singapore will have the authority to entertain the set aside application under the Singapore International Arbitration Act. So, as I said before, the timeline to file this application varies from country to country. So, based on the seat of arbitration, the timeline also varies. And next is the grounds which will be referred by the parties to file this set aside application. This plays a crucial role. There are few things which will be considered by the parties. Sorry. Okay. These are the things based on which the set aside application would be filed by the parties. A party was under some incapacity or incompetent. So during the execution of arbitration agreement, if either of the party was incapacity, for example, if he is a minor, or his mental condition was not stable, so that kind of things could be raised during this set aside, I mean, challenge petition. And if the arbitration agreement is not a valid one, it does not have any valid terms, and if it has not been addressed by the arbitrator properly in the award, so the such kind of arbitration award could be subject to set aside application. And next one is if either of the party was not given proper notification regarding the appointment of arbitrator, of course, the initiation of arbitration proceedings or some other hearings, or if either of the party was not given equal opportunity, so that could also be treated as ground, and the parties also, uh, file the set aside application based on these grounds as well. And in the arbitration award session, I was mentioning that the tribunal should make sure that he addresses all the issues in the award itself. So if he misses or fails to award any of the issues, so that could also be a ground for the parties to file this set aside application. And if the award enforceability, and if some of the terms in the arbitration award are uncertain or ambiguous in nature, so that could also be a the ground for set aside application. And we have been saying this time and again, the arbitral tribunal should not go beyond the references made, that is the contract terms and the disputes which have been referred. And he has to address whatever things being claimed by the parties in the arbitration award itself. So this award should fall within the submissions of the parties made during the arbitration award. So if it goes beyond that submission, obviously that could be treated as a ground for set aside application. And the composition of arbitral tribunal. In the arbitration agreement, the parties could specify the number of arbitrators. They can specify it as a sole arbitrator or three or five. So if such number, the proceedings are being conducted um, without not in complaints to the arbitration agreement regarding the composition of the tribunal. So that could also be a raised as ground to set aside the arbitration award. And if the subject matter of dispute is not capable of adjudication by the arbitrator, so that could also be given as a ground. For example, if it is a criminal dispute or matrimonial dispute, in India, matrimonial disputes are not subject to arbitration. So we have to check into the limits of the country for arbitration. And so subject matter of dispute, if it is not capable of adjudication by the tribunal, so that also will be a ground for set aside. And next is the award is being induced or affected by fraud or corruption, or the tribunal is being biased by any of the parties. And if the other party has a proof of that, so definitely that will be a ground to set aside the arbitration award. And we have been saying this conflict of interest. The arbitral tribunal should not have any conflict of interest, with the parties or the dispute or the outcome of the dispute. You should not have any relationship with all these points. So if the other party finds that there is a conflict of interest, so it is a prima facie evidence, and obviously the award will be set aside on this ground. And the award should not be in conflict with the public policy of the country, and it should not be violated by patent illegality appearing on the face of the award. It should not be perverse in nature, and it should not conflict with the basic notions, that is a principle of natural justice. So these public policy of the country, patent illegality, these are the things wherein the court has the discretion to decide. So let us see what is this public policy of the country or patent illegality, perversity nature. So these are new developments in the challenge petitions. So, if either of the party feels that the award rendered by the tribunal is against the law of the country, then they could seek to challenge the arbitration award based on that, saying that it is against the public policy of the country. Next is if the party on the prima facie sees that the interpretation made by the tribunal in the award is illogical or irrational, and it is not based on the submissions made by the parties, then the parties, the alleging party, could file the set aside application based on these grounds. So arbitral award is considered perverse if it arrives at a conclusion that no reasonable or fair-minded person could have reached based on the facts and evidences presented by the parties during the proceedings. And if the parties feels that the tribunal has ignored the material evidences presented during the arbitration, or the parties considers that the evidence is in record is not relevant or legally admissible, or misinterprets or misapplies the laws in a manner that leads to an injustice and unreasonable outcome. So if you're an arbitrator and you're drafting an arbitration award, you make sure that whatever the documents and evidences and the references made by the parties, you make sure that you include all those things in your award, whether it is correct or not. Based, you include those things in your award with the reasons, whether you approve it or reject it, so that your award would not be set aside based on this perversity and against the public policy of the country. So we have been seeing the grounds to set aside the arbitration award. So if the court decides that the ground which are being referred by the parties is correct and logic, and set aside your award, so what is the outcome of that set aside application? So first, it will be the annulment of award. The award will be completely invalidated. The award will be null and void, so it does not have any legal effect. So if the court finds that the grounds for setting aside the award are met, such as lack of jurisdiction, serious procedural irregularity, that is unilateral appointment of the arbitral tribunal, or the award being contrary to the public policy, it will be annulled and set aside in either in whole or in part. So if the award has been, invalidated, so the parties, they have to reinitiate fresh arbitration proceedings, or they can go for any kind of other legal remedies. Next is partial set aside. So either the court could completely invalidate the arbitration award. If not, uh, the court could partially set aside the arbitration award. So this can occur when only part of the award is found to be affected by the grounds for setting aside. That is, one specific issue in the award was decided in the manner contrary to public policy. So the unaffected part of the award, it remains enforceable, while the set aside part or nullified. So the other part which is enforceable, it could be enforced, and the relief, that is the money which have been awarded in that part of award, could be um, could be used out by the parties. Next is this is another outcome of set aside application, that is remission of the matter to the arbitral tribunal. So instead of setting aside the arbitration award, the court may remand back the matter to the original arbitrator for reconsideration. So this happens only when the court believes that the tribunal could correct the identified issues such as procedural irregularity or an error in the award. So in that situation, the tribunal, he has the opportunity to issue the revised to issue to review that issue raised by the court, and they could publish a revised award which may address the court's concern while preserving the integrity of the arbitration process. So all three are the outcomes of the set aside application, that is annulment of the arbitration award, or partial setting aside of an arbitration award, or remanding back of the matter to the arbitral tribunal. So now let us see the scenarios, upon which the arbitral award could be set aside based on the actual judgments by the court. So in this case, the court held that the appointment of an arbitrator at the request of appellant of the dispute without sending a notice to the respondent and an ex parte degree given by the tribunal will be held illegal or and liable for setting aside. So as I said before, the person who initiates the case, that is the claimant who initiates the case, he has to send a proper notice to the respondent regarding the arbitration proceeding, invocation, and further arbitration hearings. Everything has to be notified to the respondent, and that has to be recorded in the arbitration award. So if it is not being, if the opponent person, if it is not being notified, and if it is not being recorded in the arbitration award, then obviously such kind of arbitration award is liable to be set aside. So that is what has happened in this case. Next is whether service of notice of arbitration via WhatsApp number, that is email address, constitutes a valid delivery. So yes, time and again I have been saying that both of the parties, they have to be notified regarding all of these proceedings and invocation properly. So whether such kind of notification through WhatsApp number, that is what WhatsApp messages and email address, is valid under law? Yes, it is valid because of the electronic transfer, electronic transformation of informations. Next is whether a fresh notice is needed for recommencing the arbitration at first after first award is set aside. So we have seen that in the as a result of setting aside application, sometimes the court will be remanding the matter back to tribunal, and they will sometime, totally invalidate the arbitration award. So if the award has been completely annulled, so does the party, that is the claimant, does he need to issue fresh notice, invocation notice to the party regarding the recommencement of arbitration? So the answer is no. The court ruled that a fresh notice was not required for the purpose of recommencing the arbitration once the first award was set aside. The court reasoned that the arbitration mechanism was already triggered and the proceedings had commenced, and hence there was no need for new notice. And these are some of the disputes that are not arbitrable in India. The disputes like criminal disputes. Obviously, it is not the criminal disputes is not arbitrable in all the nations. And if it is in India, the matrimonial disputes consisting of divorce, judicial separation and restitution of conjugal rights, child custody, etc., bankruptcy, winding up, the will related matters, and the eviction of tenancy. The tenancy related matters are arbitrable in UK, but in India it is not possible. So that thing has to be checked before. That thing has to be checked by the tribunal before conducting the proceedings and passing the arbitration award. Whether a person who is ineligible to be appointed as an arbitrator can nominate another person as the arbitrator, the answer is no. So the Supreme Court held that once a person is ineligible to act as an arbitrator due to a conflict of interest, then he or she cannot appoint another person as an arbitrator. So the decision emphasized that the importance of impartiality and independence in the arbitration proceedings. So consider that an advocate who was representing the case of the claimant or the respondent maybe 2 years and 3 years before. So does that kind of, does the arbitrator of such thing, he does not have the power to appoint an arbitrator for the present case. So if he appoints, then that will be coming into the ground of conflict of interest. So in this case, the Supreme Court has clarified that mere presence of bias or potential conflict can be a ground for challenge, but that actual bias, it has to be proved. Uh, I mean, um, Mere presentation before the court is not sufficient to set aside an arbitration award, because this kind of bias and conflict of interest, it will arise in every case, but that has to be proved by the parties who wants to set aside the arbitration award. So next is patent illegality. As I said, in this case, the Supreme Court explained that an arbitration award is declared patently illegal if it goes against substantive provisions of the law, arbitration rules and regulations or terms of the contract. So if you're making an award, you make sure that your award is not going beyond the terms of the contract, and it is not against the provisions of the contract law or the arbitration law and the arbitration rules of the institutions, etc. And next, in this case, the Supreme Court has set aside an arbitration award as perverse because it completely ignored the specific terms of the contract, arriving at a conclusion that was unreasonable and against the terms agreed upon by the parties. So the court, they enforced the presence of adherence to the agreed terms without valid reasoning could result in the award being labeled as perverse. So if you're drafting the arbitration award, uh, the contract agreement, that should be the Bible, and the documents which have been submitted by the parties, you have to compulsorily refer to those documents. Also, you have to refer to the substantial law of the country. and make the enforceable arbitration award. So this case is a this case relates to the construction contract disputes. Here, the court set aside the arbitration award on ground of perversity, finding that the arbitrator had disregarded the terms of the contract and the evidence presented. So the award was perverse because it was not based on any reasonable or logical interpretation of the contract terms. So in this case, the tribunal has failed to consider two significant issues of the liability and quantum in this award. So hence, this award is liable to be set aside. So make sure that whether you accept or reject the claims of the parties, you make sure that you record in the arbitration award with a reason. So this is a UAE law, UAE judgment. So this is one of the thing which the tribunal has to look into. The tribunal has pronounced the award, and he has the duty to deliver the arbitral award properly to the parties. Mere delivery of the award to the advocate does not is not an effective delivery. He has to make sure that the award is being delivered to the party themselves or the authorized representative who completely understands and appreciates the award, who could be the best person to take initiative in the matter of moving set aside application. So, as a tribunal, we has to make sure that the award is being properly delivered to the authorized, either authorized representative of the parties or to the party themselves. If not, if the award is not properly delivered, then there will be some issues in the timeline to file the set aside application. And next is enforcement of an arbitration award. Whatever relief the parties claiming in the arbitration proceeding, the award will be there, but everything will be in the paper. So to realize the award and to get the amount, the enforcement application has to be filed by the parties before the court. So this is a separate proceeding. Once the arbitration award is being delivered to the parties, either of the party, they may go to court to set aside application, to file the set aside application, and the proceedings will be conducted. Either the set aside application will be accepted or rejected. If it is accepted, yes, the award will be invalidated. So there will be no award. If not, the award is enforceable. So the party who wants the case, they will file this enforcement application before the court. So the winning party who need to enforce it, particularly if the losing party does not voluntarily comply. So in most of the cases, obviously, losing party, they will not come forward to settle the amount. So in that situation, the winning party, they have to file this enforcement application before the court of the respective jurisdiction. So how this court has been identified. Let us see that. The enforcement is typically sought in the jurisdiction of the court where the losing party has asserts or conducts business. So the losing parties asserts and is nature of business. If he has some kind of asserts in the particular jurisdiction, obviously the enforcement application will be filed in the court of that jurisdiction. So the relief sought in this enforcement application will be through legal means such as garnishment of wages or seizure of the assets or other methods provided by local law. Sometimes, the winning party will also ask the court to arrest the losing party until the award is being award amount is being paid. So these are the prayers which will be made during this enforcement application. So if it is international arbitration award, then the parties should make sure that the losing party, the country of the losing party, is a signatory to the New York Convention, that is, which is also called as recognition and enforcement of foreign arbitration award. So this New York Convention, it applies to the recognition and enforcement of foreign arbitration award. So far, 170 countries are signatory, and they have ratified this New York Convention. So, before initiating the arbitration proceeding, you should make sure that if you're a party, you should make sure that your opponent person is, the country of your opponent person, or the assert and the business where the opponent person is running, is a signatory to the New York Convention, so that there will be no um, disturbance in enforcing your arbitration award. So this convention shall apply to the recognition and enforcement of an arbitration award made in the territory of a country other than the state where the recognition and enforcement of such award or sought. So this enforcement application, the timeline varies from country to country. If it is in India, it will be 2 years, and for UAE, there is no strict timeline, and UK, it varies from 6 years to 12 years.